Hello, welcome to Workplace Wake Up. I'm Jen Shaw. Every week, I spend about 15 minutes covering key legal developments, introducing you to interesting guests, and providing some entertainment to start your workday. I hope you enjoyed this week's episode. I am so happy today to be here with Kris from our office. Kris, how are you today?
I'm well, Jen. How are you?
I'm doing good, and I'm happy to talk about DEI. Oh my goodness, there's so much to talk about in this area. Just so all of you know, Kris is an attorney in our office. He's amazing. He does investigations. He does advice and counsel. He does audits. He does training. Some of you may remember him from our legal update that we did for 2025. And we have been talking a lot about the executive orders that President Trump has issued and what to do about them and what they mean for the workplace and all of that. So I wanted Kris to be on today because he's really been following the DEI developments. And I want to really, Kris, I think, focus on today this idea of what are employers supposed to be doing right now? I mean, there's a memo that a bunch of attorneys general issued saying, look, DEI is actually good for the workplace. It actually reduces potential employer liability. But if you read the executive order, it's the exact opposite. Kris, what are employers to do at this point?
Yeah, well, you really hit on the issue, Jen, which is that we've had more guidance. We've had new things trickle out since your last episode on this a few weeks ago. And all of that guidance together has just made the situation clear as mud. We're not any closer to understanding what the federal government meant by illegal DEI. As you noted a few episodes ago, that wasn't defined in the executive orders. It still hasn't been defined in all the agency memos and further guidance that has come out since then. Not to mention that even in the business community or legally, as you know, DEI isn't a set thing. It's going to look different from business to business. You know, DEI and DEIA is not one rubric that everyone follows. It's a pretty nebulous buzzword.
Well, it's interesting, too, and I'm glad you brought that up, Kris, because, you know, some people call their DEI DEIA, where they add accessibility, or DEIB, where they add belonging. This idea, I think, has taken on a life of itself. So the other day, some of you know, Ella and I went to Yellowstone. We were flying home a couple weeks ago, and there's a guy on the plane, and he's talking about political issues. So I'm just kind of minding my own business. But then he says, what do you do for a living? And I said, I'm an employment lawyer. And he goes, aren't you glad all those DEI hires are being fired? And I said, well, that's an interesting issue, sir. What is a DEI hire? He goes, well, you know. I said, no, I actually don't. What do you mean by a DEI hire? And he had this very complex sort of definition, Kris, about, well, it's somebody who was hired who shouldn't have been hired. And I said, well, okay, but do you think everybody who is hired as part of equal employment opportunity should not have been hired? I mean, isn't that a good thing? Don't you want everybody to have equal access? I want qualified people. Well, Kris, as you and I know, there's nothing in DEI that says you should hire less qualified people, right? That's not the point. That's not the point of a DEI program. The point of a DEI program, of course, is being more expansive, bringing in different viewpoints, different values, different abilities to the workplace. So one of the things that I find really confusing about the executive order is that I don't even know what the target is, what the focus is. I mean, the president has blamed all kinds of things on DEI that don't seem to bear any relation to reality. So as an employer, forget about the politics. As an employer, I think it is a very confusing thing because we are required, for example, in California, to do training on equal employment opportunity. We're required to have policies promoting equality and equity in the workplace. So what kind of ideas do we have for employers, Kris? I mean, literally, there are different types of employers, right? Some of them have federal contracts. Some of them are federal agencies. Some of them are private sector. But one of the interesting things about this executive order is they're trying to reach just about every employer in the country, right?
Absolutely, yeah. Yeah, we have two executive orders here, one aimed at federal contractors and grantees and federal agencies, and the other one to encourage the private sector, which we've seen some of that encouraging kicking in with these vague memos from government agencies, the CDC telling its grantees they have to immediately terminate all their diversity, equity, and inclusion programs. No comments about illegal DEI, just all of it gone. The FCC sent a letter to the CEO of Comcast saying that NBC Universal was promoting invidious forms of DEI, and it was the FCC's goal to shut down any programs that promote invidious forms of DEI. So we are seeing that being applied and some pressure being applied to the private sector too. Again, with no clear guidance on what these things mean. As you mentioned, 16 attorneys general, but all from blue states, Democratic states, have come out and said, the president can't unilaterally do this, and these initiatives are beneficial to the workplace. And as you mentioned a few weeks ago and just now, the whole point of these DEI efforts are to promote merit-based hiring, for us to get and retain the best talent. What's important, though, is to not give preferences based on a protected category. The point of these programs is to cast as wide a net as we can in recruitment, help people be comfortable and confident and want to participate in the workplace, so retention. And these two things together also have the added benefit of expanding our recruiting pipelines, opening up new recruiting pipelines. Just as employers, we want to make sure that what we're not doing is showing a preference towards one group or another. But it's okay to keep making a wider and wider net so that we can get as many people in our recruiting process and retain as many people as we can.
So let me ask you just a basic question, Kris.
Yeah.
Should we even call it DEI anymore? Does it make sense to just call it something else?
Well, from my perspective, and this is gonna be employer to employer and what they want to do and what they have a tolerance for. DEI is the big buzzword that is being targeted right now. I prefer to just call it diversity, equity, and inclusion, because as we talked about at the top, there's no standard DEI. So what we're talking about is these separate things and how we strive to include those things in our workplace.
Okay, so I like that. So not actually using the acronym DEI, but actually talking about our commitment as an organization to diversity, equity, and inclusion, and then defining those terms in our organization so that everybody sort of understands this is what we're actually doing. By diversity, this is what we mean. By equity, this is what we mean. By inclusion, this is what we mean. Okay.
Mm-hmm. And keep those terms broad. We don't need to call out a specific group or say that we are, promoting one category over another. We want equity for everyone in the company. We want everyone to feel included. We want everyone to feel like they can participate, and we want everyone to raise concerns when they have them. So we just need to communicate this stuff generally and make sure that we're being inclusive of everyone in the workplace, not showing a preference for someone or another.
So what's interesting to me, too, is that we're in a pretty tough hiring cycle. In this country, it is hard for folks to find employers. I mean, we've struggled in our own law firm. We could use a couple of additional lawyers. We could use an additional secretary, and it's hard to find qualified people. So one of the things I think is important, too, is that employers don't throw out this really important, I think, as you said, Kris, recruiting and retention tool with the bathwater, right? You throw out the whole concept of DEI. You really are losing something as an organization, I think, in terms of getting people who want to be part. I mean, this is a buyer's market, right? This is employees have a lot of options about where they can go and what they want to do. And so the idea is, look, do everything you can to recruit the best and the brightest. And if you are throwing out DEI, we're seeing a lot of backlash against employers that are doing that, right? There are applicants who are saying, I'm not going to apply to a company that is not still committed to diversity, equity, and inclusion.
Absolutely. And after a lot of these big brand name companies, threw out their diversity, equity, and inclusion programs just wholesale, the Department of Justice issued some more guidance, and they specifically said that things like historical observances, educational events, and they include examples like Black History Month, International Holocaust Remembrance Day, similar activities, that's all okay. That's not what they were talking about within the realm of, quote, illegal DEI. Now, we didn't get a definition on what illegal DEI meant, but we got some indications that a lot of the popular programs for employees were okay. We didn't need to get rid of those.
What's funny is it almost feels like the administration is seeing the world 40 years ago, right? When we were first dealing with equal employment opportunity at work, and we were realizing that women and people of color had not been given the same opportunities. And the way that was sort of implemented in many workplaces was through a consent decree, literally a legal requirement, a court order saying you must hire people who fit these molds because that's the only way we're going to be able to get you in a situation where you've got some parity compared to your workplace and the community where you are operating. We don't do that anymore. There are very, very few employers that are still subject to consent decrees. I was reading a couple weeks ago, literally like fewer than 1% of employers are subject to a court order that requires them to hire certain individuals as a remedy for past discrimination. So it's almost as if the order is focused on those issues, right? Because what they're really looking at is you shouldn't be, as you said earlier, Kris, preferring a certain group. But I haven't reviewed a DEI program in 15 years that actually does that. The early ones did, but the ones now are talking about, no, we welcome you. We welcome who you are and what you're doing and your different values and your different perspectives. And we sure don't want to get rid of that.
No, absolutely not, because like we mentioned earlier, and there's been studies showing this. For example, McKinsey & Company, a major firm here in the U.S., found that companies who are in the top quartile for diversity, inclusion, and equity practices who really take it seriously, they're a lot more likely to have better financial gains above, what is known as the industry median. So people who have these practices, it's not theoretical. It's been shown that it helps with recruitment, it helps with retention, and having a huge choice of applicants to pick from lets you get the best of the best, and retaining the best of the best just helps your organization shine above your competitors. So these are still positive practices. There are still real business benefits to doing it. We just want to make sure that, one, we're complying with the civil rights laws that have been in effect, as you pointed out, for decades now. And that we want to make sure that we're communicating about this stuff correctly, that we're not showing a preference, and we're letting all of our employees know, regardless of their backgrounds and regardless of their opinions on diversity and equity and inclusion issues, that they have the same rights and protections in the workplace.
That is so interesting that you brought that up, Kris, because we talked a few weeks ago about employees' rights in terms of speaking out. Obviously, public sector employees have First Amendment rights. But even if you're a private sector employee, certainly in a state like California, you have a right to express your opinions. And I think one of the things that's been happening in the workplace recently is it's very difficult to see the other side of an issue. We have all become pretty entrenched. I know from my own political views, it's very hard for me to understand how anybody could see things differently, because to me, it's just so obviously not valid or not correct. And that is not the way to approach these situations, right? We have to become a little less entrenched, and we have to be able to understand that employees in our workplace are going to have different views. They're going to have different perspectives, and we can learn from each other. And that doesn't mean we have to agree. I mean, one of the best things anybody ever said to me was, look, we can disagree to disagree. That's okay. That doesn't have to end our friendship. It doesn't have to end our work relationship. It doesn't have to end our camaraderie or our communication. We can just agree to see the world a different way, and that's okay.
Absolutely. And it does make it difficult when we're having these disagreements with our employees, especially when they're disagreeing with our policies, with the way that we are making decisions and doing things. But again, just focusing on diversity, equity, inclusion, accessibility programs. Like you mentioned, we have to keep an open mind. We have to respect people's opinions. We don't have to tolerate harassing or intentionally disrespectful language. That's a whole different episode. But the trick is that, diversity, equity, inclusion, accessibility programs, they're not meant for one group or at the exclusion of a larger group. These are protecting every employee's rights in the workplace. And that's the important thing, is communicating to our employees, to regulators, to whoever has an interest in our programs, that this is a program about protecting everyone's rights.
Kris, that is such a great point, and it's a great point to end on. We like to keep these short and sweet for those of you who are driving to work or on your exercise bike or wherever you're listening. Kris, thank you so much for sharing your perspectives today. They're really valuable, and I'm very grateful for your willingness to come on today. Thank you so much.
Yeah, thanks so much for having me.
Everyone, thanks for joining us. Go out and do something nice for someone today, and we'll see you next time. Workplace Wake Up, including our guests and hosts, do not provide legal advice in this podcast. Do not act upon any of the information discussed in this podcast without first consulting a licensed attorney in your jurisdiction. If you enjoyed this episode and would like to spread the word, please share it with others, post about it on social media, and/or rate and review it. You can also follow us on LinkedIn, Twitter, and Facebook, and email us at info@shawlawgroup.com.